It's already a busy day, but this team will not allow me continue my day without talking to you about the Constitution of the Federal Republic of Nigeria. Have you heard about the Constitution? Most of us know that the Constitution is the ground norm of the Federal Republic of Nigeria. Unfortunately, a lot of us are ignorant of the provisions herein. Yes, ignorant. Whether you're a graduate, you are a secondary school leaver, as far as you are a Nigerian, it is your right to know the provisions of the Constitution, especially because the law said ignorance of the law is not an excuse. Now you may be ignorant, but we have made it a point and a duty on us at Ishaku Legal Hope to educate you on the contents of the Constitution. Today we'll be dedicating our time on Section 36 of the Constitution. We'll be talking about fair hearing. There are a lot of things you will learn in Section 36. You learn about presumption of innocence, you learn about fair hearing and all that entails in this section. Make sure you stay tuned. This is Ishaku Legal Hope. Subscribe to our channel, hit the notification button, and it's going to be a great time learning the law from us. We'll be teaching you all the time. Oh yeah, now, I had a friend back in the university until date. Anytime he sees me, section this, and anytime they see lawyers, they want to cut sections. It's not in the cutting of the sections. It's in understanding what the section entails. Now, let's talk about presumption of innocence. By the Constitution of the Federal Republic of Nigeria, anybody that is charged or alleged to have committed any criminal offense, the Constitution says such a fellow is presumed to be innocent until proven guilty. Now, who has the responsibility of proving him guilty? To the common man, if you meet a person stealing something, you conclude that he is a thief, taking what does not belong to him. But do you know that you don't have the right to tag such a person as a thief? Do you know that you don't have the right to punish such a person by the provision of this Constitution? The Constitution says such a fellow has to undergo a prosecution. The only body entitled and given the responsibility and right to declare a person guilty is the judiciary. So it is only the judiciary that will be able to pronounce a person guilty. So if we look at this now, we have a lot of cases of lynching and all that. People will just lynch on people. I think, what do we call it? Jungle justice. Jungle justice is against the spirit and provision of Constitution of the Federal Republic of Nigeria, which is the ground norm guiding every activity and every sector. Now, if a person is charged with an offense, or if the person is alleged to have committed an offense, the right thing to do is to hand him over to the authorities. And who are the authorities? You hand him over to police. The police will do their investigation, and after investigation, the person will be charged to court. If the court at the conclusion of his trial declares him guilty, then that person is guilty. If not, you have no right to tag that person with any name of the offense he has committed, as long as the person has not been convicted. Don't forget to hit the subscription button and keep following us. Now, I hope you understand presumption of innocence. So don't go about calling people thief, armed robber, and all that, as long as the person has not been pronounced as such by the court of competent jurisdiction in Nigeria. Now we're going to take you on another issue under Section 36. That is the issue of fair hearing. What does the Constitution say about fair hearing for a person that is charged or alleged to have committed an offense? There are things that are entailed and provided by the Constitution that completely constitute what is tagged as fair hearing. Now, once a person is charged with the commission of offense, the Constitution provided that he should be given adequate time and facilities to prepare for his defense. Now, what are these things that will constitute adequate time and facility? If you are charged with a criminal offense, the nature of the crime committed will be told. You have the right to be informed, and then you have the right to be given the opportunity to gather every material evidence you need for the defense of yourself. You also have the right to have access to the lawyer of your choice. You have a conversation with your lawyer, whether a person is on detention or not. You have a right to have access to your lawyer. That is why even while you are in detention, Your lawyer can have access to you, discuss with you, understand all the things you need for the defense of the case against you. Regarding the facilities and resources you need for your defense, all the documents intended to be relied upon by the prosecution in prosecuting your case has to be handed over to you, which will be studied by you or your lawyer in preparation for your defense. Now, another thing you know is that you can decide to defend yourself personally or through the lawyer of your choice. Now, most times it's advised and it's best for you, especially because you don't understand the law and you don't understand the proceedings. And then from high court above, you cannot even defend yourself as a person. So it is best for you to get a lawyer of your choice, even though the Constitution said you can defend yourself personally or get a lawyer of your choice. This is very important. Don't be ignorant. Another person took about 5 years, 6 years, 7 years to study law. And then you are there to say, I can equally defend myself. What is there? We have seen a lot of people make a reckless decision, especially in civil matters, on the ground that I will defend myself. Not everything that is provided is necessary for you. There can be provisions that are available for you, but not very, very helpful. One of such is defending yourself by yourself. Yes, it is your right, it's your constitutional provision, but I will advise you to always get a lawyer. More so, if you are charged with a capital offense, whether you have a lawyer or not, the court will not proceed without you having a lawyer. In instances by the provision, the court can even decide to give you a lawyer that will represent you, because capital offenses are very, very serious offenses that carry punishment either of death or life sentence. It is very clearly provided that in such offenses, the court cannot proceed with the case without you having a lawyer to defend you, to understand the gravity, and then to put up defense for you. So these are things that you necessarily need to know and to understand about fair hearing. Do well to keep following us on this channel. We'll make sure you have so much information on the Constitution of the Federal Republic of Nigeria. We take it as a responsibility, and all we demand from you is be open to learn, listen, and keep following us. Don't forget to hit the notification button, subscribe to our channel, and drop your comments. Send down your questions. We will do well to take our time, respond to your questions, and respond all the time and at any time. We see you in our next video.